cleaned up in the Superior Court of Norfolk on 2019?
On August 18th of 2019, he filed a request for juror information to get the jury list, the jury pool list.
No.
And I filed this response saying that I thought because it was the prospective jurors that there should be some higher standard. The Judge Sullivan allowed his motion, and so he won. I lost.
Yeah.
The judge disagreed with me on the point of law, and then he sent something to the jurors, prospective jurors, I believe on December 31st.
Okay. So there was a hearing somewhere around October of 2019 when you filed your response to his request for juror information.
Correct.
Okay. In the second page of that, you write, under Mass Rules of Professional Conduct 3.5 small d, counsel may not contact any juror without permission from the court. See Commonwealth versus Moore, and they cite it. Now, I've read Moore, and Moore doesn't say that. I can't find it saying that at all. That, in fact, Moore says the opposite, that counsel may file for the list and without the permission of the court. Correct?
I'm trying to find, I had a copy of Rule 3.5 with me. Oh, I do have a copy of Moore.
Yeah, and 3.5 overturned parts of Commonwealth versus Fiddler, right?
Correct.
And it allowed a defense lawyer or the Commonwealth, I guess, to
Correct.
be able to file for the list and send something to a juror without
Correct.
permission from the court.
Correct.
So, but you say in your filing,
I see that here, and I stand corrected. I'm looking for Rule 3.5 because I don't know whether it's in that what I was quoting, or if I was looking at an old version of the rule, perhaps.
no, you quote Commonwealth versus Moore,
Well,
2016, 474 Mass 450-41.
correct. I cite to it, but I said under Mass Rule of Professional Conduct 3.5D. So I'm just not sure what that rule says. I understand that after Fiddler, the SJC and Moore changed the law from what it had been under Fiddler, where it had been a strict prohibition, to make it much more flexible.
Well, the court said in Moore that the court concluded that the adoption of Mass Rules of Professional Conduct 3.5 small c in 2015 effectively overruled the rule established by Commonwealth versus Fiddler.
Correct.
Correct?
Correct.
And so when you cited Moore, that was not correct, was it?
No.
Okay. And then you cited Moore again on your last page when you say the court should also order that counsel may not attempt to contact any of the prospective jurors on the list without further order of the court upon motion in compliance with Mass Rules of Professional Conduct 3.5 small d and Moore 474 Mass at 551. So again, you cite Moore as authority to the court to deny the request to contact prospective jurors.
Right. My memory of Rule 3.5D is that it says something to the effect of except upon order of the court, or the court may put restrictions on the contact. Words to that effect. And that was what I was trying to argue. I
Then
understand.
why did you put Moore as your cites in both places? If
Well, I understand that is better left unsaid, but I was trying to make,
Well, this is my issue. To me, the appeals court and the SJC to some extent are places where judges go that are very smart, and you're very smart, and I give you a lot of credit for your background. But it's also a place where filings are important. And making sure that you have the right cites and filings are very important, right?
yes,
And it seems to me that on this document anyway, twice you cited Moore, and that was not the holding in Moore. So to me, detail, especially with you appellate lawyers, us regular dopes that go to court, we get things wrong all the time. But you guys, I find, don't usually do that. You're very precise to make sure that the filings are correct,
correct,
because you sign your name to them, right?
correct.
And you don't want a judge looking at it and saying, what the hell is she talking about? Moore doesn't say that at all. So I think that's what Nathanson was saying, that you didn't pay attention to detail.
I understand that. What I should have done is I should have said CF to Moore, because I saw Moore as an analogous situation, because that involved trial jurors, and I was trying to make the point in this memorandum that on the facts of this case, that the standard should be a little bit different for prospective jurors. I lost
Moore
that.
doesn't say that.
That's why
Moore says he can do exactly what he did
with respect to trial jurors.
with whatever he was asking for. In fact, the court ruled in his favor.
Correct,
The court said he's right.
correct,
And the court said Moore gives him the right to do it.
correct.
And you argue the opposite. Moore didn't give him the right.
I tried to distinguish Moore because
Yep.
Moore involved trial jurors.
But
and
you didn't. You said counsel may not contact any trial juror without permission from the court. See, Commonwealth versus Moore. That is not correct. Am I wrong?
I don't believe you're wrong.
Okay. So I think that was his sort of complaint about it. So let me go on to Mr. Chinman here. Let me ask you, you said to Counselor Kennedy that it is important, and you always do it when you're in the appeal section of whatever DA's office you're working for. When you get a case, you get the trial file because it's important to see what's in there.
Most of the time.
When wouldn't you do that?
If there was an issue that was raised that could best be answered by only looking at the record in the case. So for example, if it involves a question about jury instructions, I might confine myself to looking at the appellate record, and I might not reread police reports, for example, in the prosecutor's trial file.
Well, there's a lot more in the trial file than just police reports.
Correct.
There would be the motions filed for jury charges. Right.
I would ordinarily get those from the record, the clerk's office.
But wouldn't you want to see if they were in the file also?
Well, my concern would be that sometimes what's filed in court is different from what's in the prosecutor's file, and they might have a draft that they didn't file, and I'd be very cautious about not wanting to mistake a draft for the final product. I'd first go by what was in the clerk's papers. If it looked like...
I don't get that. So you wouldn't go into the file because there may be a draft in there that you wouldn't want to take and file it?
Well, so if I'm dealing with a case on appeal and there's an issue with respect to jury instructions, I will go to the court, to the clerk's office, and look to see what the Commonwealth's request for jury instructions are that was filed in court. the version that's got the stamp on it, it's signed and filed in court. The prosecutor might have a copy of that in the trial file, but I would never put the prosecutor's copy from the trial file in a record appendix filed in an appellate court.
But wouldn't you want to know, looking at the trial file, what the case was about, what the evidence was that the DA put in, and to be able to see whether he filed the proper request for instructions
Sure,
based on the case?
I would look first at the clerk's papers because that's the appellate record.
Then you'd look at the trial file?
Particularly if it appeared that something was missing from the clerk's papers, or there was something, if it looked like something was missing, or if I had questions about something.
Well, what was the procedure at Middlesex when you got a case? How did you know? You were in your office, did Mr. Sahakian come in and tell you to take the Jubinville case?
Usually,
Okay. And what did you do then after he told you that?
usually the first thing I would do would be to get the blue brief, the defendant's brief. I would get the transcripts and I would start reading the transcripts. I usually would wait until I was part of the way through the transcripts before I would go look at the clerk's papers, because that would give me an idea of which clerk's papers to focus in on. I would liberally take copies of things from the clerk's papers to put them in the record appendix with my brief. At some point in there, I would ordinarily get the trial file and review it and see if there was anything in there that was relevant to an issue on appeal.
So he says that he would be given a file, he would be given a case from his administrative, from Sahakian's administrative assistant. She'd give to the person who retrieved the files trial, and it'd be some manila envelope. Usually it was called a CTU. Do you recall what that means?
It's a prosecutor's trial folder.
And he said that somebody would go and retrieve that file and bring it to him.
Correct.
And it seems to me, since you're in the office and the file's in the office, wouldn't that be the first thing you sent somebody to go get, is the file, so you had it?
Sometimes.
I don't get the sometimes. Why?
Well, because
First of all, when he gives you the case and he says Commonwealth versus Jubinville, you got that case.
correct.
You fill out something and have somebody go retrieve that file.
Yes.
You don't know Commonwealth versus Jubinville from a hole in the wall at that point, do you?
Yes. Correct.
Right? So wouldn't the first place you'd look is to get the file and kind of review it to see what you're looking at here before you go see anything else?
The clerk's file, the court's file, is what I focus on because that's the appellate
No,
record.
I'm asking about the DA's file.
Correct.
You work for the DA's office. Your boss comes in and says, I want you to do the appeal in Commonwealth versus Jubinville. You fill out some sort of a
File. I mean, a
file,
request.
and he said usually Scott Sarsfield would go and get the file back.
Correct.
Then. So he's saying, as soon as I got notified of the case, I didn't know anything about it. So I'm in the DA's office, in my office, the file's in the DA's office. I'd say to somebody, Sarsfield, bring me the file, so I know what I'm talking about here, right? That would be the first thing you'd look at, wouldn't it?
The first thing I would
As a reference point?
first thing I would look at would be the defendant's brief, usually the blue brief.
You don't even have the brief yet, do you?
Oh yeah, that's when you get assigned the case.
Okay. Okay, so you don't always look at the file.
I would say unless it was missing, I would look at the file. Unless it was,
How would you see it if it was missing?
I wouldn't. That's what I'm saying. For example, in the Rodwell case where the file was lost, I didn't look at the file. But in every other case, I would always look at the file. It wouldn't necessarily be the first thing I would look at.
So, but in every other case, you'd look at the file.
at some point.
No question about that. You'd do that. Every appeals person would do something like that, wouldn't they? If they were doing the proper job.
Well, probably.
So you remember testifying at the Rodwell hearing in 2016?
Yes,
You were on the stand.
yes,
You were under oath.
yes.
You were asked a lot of questions about the file and about you getting the file.
About this was the file that I looked for in 1998, and I determined that it had been lost.
Well, my question is, you were asked a lot of questions about the file in the Rodwell case.
Correct.
You were asked questions about looking at files as a normal part of your duty. And you indicated in that transcript that I read last night that you don't always look at files.
And
Didn't you say that?
I don't have the transcript in front of me. And if I said that, that's what I said.
Well, it's not, you said it by my reading of it a bunch of times because she kept after you about
Right.
that issue. And you kept saying, no, I don't always look at the file,
Correct,
right?
correct.
So that's different than you said today when you said, I do always look at the file at some point.
I said if it still exists.
No, you didn't say that. You
Well-
said to me a little while, 2 minutes ago, that at some point I always look at the file, except if it's missing,
Right,
right?
except if
Okay.
it's missing.
When the transcript that I read last night, we weren't talking about the Rodwell case. She was asking you in general your procedure. And you
Oh.
indicated that you don't always look at files. Correct?
That sound correct, but
Okay.
the issue was in Rodwell.
No, I know, I'm gonna get to the issue in Rodwell. So, part of the thing here is, especially for the appeal, like I said, being thorough and accurate is a big deal in the appeals court. It's a big deal in the appeals section of a DA's office. Because if something is wrong and it's filed, somebody may end up doing jail time because of that wrong
Correct.
filing. So it's imperative, is it not, for the appeals lawyer to make sure that what comes into that court signed by that lawyer is accurate?
Yes. I think we might be having a miscommunication about my focus on appeal is the file record, the appellate record, which consists of the transcript, and the
No,
exhibits.
I know that. I wasn't talking about that.
Okay,
The other thing that's very important about being a judge is listen to the question. I asked you about the trial file. Chinnan says, as a practice, you were given the case, he sent a slip or name to the Sarsfield who was runner. He went down, he got a file, and he bring it to your office. And then I would start doing whatever I was doing. You said you didn't do that all the time, but every case, unless the file was missing, you looked at that file.
at some point.
Okay. And I pointed out to you then last night when I read your transcript under oath, you are adamant about the fact for a couple of pages of testimony that you didn't always look at the file. There's no need to look at the file. You said that.
For example, in the
No, I didn't ask you for example.
That's correct.
I said, that's what you said. Does that refresh your memory what you said on the stand?
No, I have never seen that transcript.
Did you dispute that I read that last night and that you said that? Wouldn't lie.
I've never seen the
I'll
transcript, so
give
I
you the
can't.
transcript. You read it. Okay, now. I'm not going to get into the long history of Rodwell, but it was certainly a contentious case. It was about 8 motions for new trials. And, he was screaming that Nail, the chief witness, was a confidential informant of Detective Spartinos, and that he was being he was an agent. They were arguing he was an agent at the time that he gave Spartino the jailhouse confession from Rodwell, correct?
I vaguely
Yeah.
remember those details.
And as an aside, what do you think about jailhouse confessions?
They can be problematic unless there's corroboration.
There was none in Rodwell. There's no corroboration, was there? He was the only one that said that Rodwell admitted to him. There were 2 witnesses in Rodwell, Nagel and I forget the other guy's name. And the other guy said he was at the scene, and Nagel said he was in jail with him. He told me in jail.
I don't remember the details of the case.
It seemed to me anyway that jailhouse confessions should really not be allowed in the Commonwealth, because somebody is doing time, and they could get to somebody, get to an inmate that will be their key for a reduced sentence. So you never know whether they're telling you the truth or whether they're doing it because you're getting a reduction in sentence, correct? Because you weren't there. You never know. When the inmate says he told me he killed the person, it's just supposedly two people there. And there's no way to dispute it. The juror would believe that a lot of times.
Sometimes there's enough detail in the confession that matches the forensic evidence that makes it credible.
I'm going to tell you about that. Just so you know, when you're sitting on the appeals court, when there's somebody screaming about a jailhouse confession, I do not give, unless the client insists upon it, any documents concerning the case. Some clients, hey, I want all the information. And I say, that's a very bad thing in jail. Because it's very easy for another inmate to get into that record and to read it. And when he reads it, he now knows a lot of facts about the case. So he stands up in court and he says, he told me he did it. He told me he was a gray Chevy. He told me it was at night at a bar room. And the juror said, well, he knows everything about it. And it's usually, if he's lying, it's usually because he got a hold of the file. So when you're sitting on the appeals court bench, remember that. It's not all, oh, he was here like he was. How do you get the details? That's the question.
Right.
And in this case, not only did Nagel say he was an informant, but Nagel was doing 10 years. In that hearing before a judge in Suffolk Superior Court, the DA asked for those 10 years. And Detective Lieutenant Spartacino went to the sidebar of the judge and talked to him off the record. The judge got reduced the sentence to 5 years, which to me is pretty telling because Spartacino was the investigator on this case. So the quid pro quo was, you testified, told you, how did you read this sentence? You know, I don't usually see people with this many appeals, this many motions, this many over 35 years, unless there's something to it. But that's another matter. Okay, let me just ask you a couple other things on Mr. Chin. He said on the Dwyer issue that you wrote a memo. Mm-hmm. There were many iterations of memo giving numbered step-by-step guides on how to ensure the records are not turned over as part of the discovery or pursuant to the Dwyer motion. Is that true?
No.
You never told or wrote anything about Dwyer about not? Well,
I wrote a long Dwyer memo. It was actually pre-Dwyer. It was under Bishop, which is the precursor to Dwyer. It discussed how to handle these motions, when to oppose them, when to agree to them, how a victim's rights, privacy rights, and statutory privileges might interact with the prosecutor's obligation to look for exculpatory evidence.
So he says the guidance was pretty extreme. Again, often exhorting prosecutors not to learn things that would need to be turned over. I'm sure copies of those memos still exist at the Middlesex District Attorney's Office. Did the guidance talk about not turning over things? Would not turn over things if you didn't look?
No. It explained that a victim in a case is not an agent of the Commonwealth, and so the victim's records are not in prosecutor's possession because of the control.
I know. We're talking about narrow issue. Twice he said that you would not get the files all the time. All the appeals prosecutors did that, got the file, except Marguerite. And she was not shy about stating why. She gave trainings to other ADAs explaining, if you got the trial folder and looked through it, you might find undisclosed exculpatory evidence. You might find errors in the prosecution's case, and then you would be obligated to disclose those things. Did you ever make comments like that?
No.
Why do you think Mike didn't come in and say these things that they were completely untrue?
I don't know.
You have that 60-page?
Yeah.
Memo there? Would you make sure we get a copy before?
Yes.
Okay, the last thing I'll get into is this thing with Belcher. This was a resentencing on this guy's ships, right?
Correct.
and she filed a motion to have him resentenced.
Correct,
You were the lawyer on the other side.
correct.
She says that Mr. Shipp admits that the Commonwealth's opposition supporting materials contain false statements of law, false statements of fact, misrepresented and misleading materials, and omissions of significant omissions. And she indicates the first one, which you've discussed, she calls it false evidence. And there were police reports. She indicates that you filed Exhibit A and Exhibit B. There were a total of 60 pages of police reports that you submitted in Exhibit B. Is that approximately correct?
I don't remember.
Was there a lot of police reports you filed?
I don't remember. I remember this one with this one that's the issue.
She says the exhibit have 60 pages. Exhibit B, 7 pages were duplicates. 9 pages, however, are police reports unrelated to the adjudication and conviction of William Shipp Jr. The 7 pages were duplicates.
I don't remember.
And the first claim is that you put in his record claiming he had the OUI, and you said that was a mistake. You apologized for it. That it was actually his father, correct?
Correct.
His father's name was William M. Shipp Sr.
Correct.
So you didn't notice that senior and junior was a discrepancy?
Well, neither conviction, to my memory, had the word senior or junior on it.
But you were dealing with a juvenile,
Correct.
and this fellow was 40 years old.
Correct.
That didn't cause you to,
I didn't look closely enough to see the dates of birth. That was a mistake that I made. I was so focused on trying to have an open file policy and make sure that the judge had everything that was in versus District Attorney Banks's file that I should have looked more carefully. And that's a mistake.
that's a pretty important thing to be able to look carefully, right?
Yes.
If she didn't pick this up, then this would have an effect on what was going to happen on the resentencing and probably any parole board hearing, right?
I don't know.
Well, you know, would have had an effect probably on what the judge would have done with the resentencing. He says, this guy's got a prior record.
Well, I don't know that OUI dismissed court costs would have an effect on sentencing for a double homicide or much of one.
I think a point being made is it's another case like we discussed before. You didn't pay attention to the file. You didn't go over and redo it and make up mistakes. Right? You okay, or are you not interested in my question?
Oh, no, I was looking to see if I had the piece of paper you're reading from.
Okay. So it's just, I point that up again because you're going to the appeals court where precision is key.
Yes.
The next thing he claims is that a report was filed saying that Mr. Shipps was arrested for larceny on September 20th, 1983. And that you swore under oath that police reports for larceny from a person arrested on September 20th of 83 are attributable to Shipps. You recall that?
I don't, as I sit here now, and I tried last night to get documents responsive to what you're talking about. And I don't know if I got them all, so I'm not.
Well, he put that in her filing about what happened on this, right? You remember reading, she put that in there?
Sorry, what was the question again?
The question was that she says that you filed an arrest report claiming it to be Shipps under oath. That police reports for larceny from a person's arrest are attributable to Shipps. It was, in fact, a 27-year-old Negro male, Bobby L. Leslie, that was arrested. Exhibit B, she cites the case number. ADA Grant is well aware that Shipps is not 27-year-old Negro male arrested on September 20th, 1983, as reflected in the police reports. Huh?
I think what the issue was that I took everything that was in Bob Banks's file of certified convictions and I put those all before the court. I should have been more careful.
So this was not even the name of Shipps on it. This was some other guy's name, Bobby Leslie, a black male. You put that in to the court filing under oath saying that this is true.
My best memory of my affidavit is that I've heard that these are the documents from District Attorney Banks' trial file.
I know that. You were the one submitting it.
Correct.
You were the one looking through the file to make a response to her motion for reconsideration sentence.
Correct.
You were the one putting together the affidavit or the opposition motion, give it to the judge to read.
Correct.
And you had his father in one, the second one was a guy that was not even by his name. How did you miss that?
I was trying to be conscientious by putting before the judge everything that was in Bob Banks's sentencing file. I didn't necessarily.
Wait a minute, you wouldn't put in things to the judge that had no bearing on this defendant that was before Judge Hunter.
Correct.
You wouldn't put in there saying, here's everything you know about the guy, and put in reports of somebody else's arrests.
It appears that's what I did as making a mistake.
So that
And
was
I
a mistake.
apologize for that. Yes.
2 mistakes.
Yes.
Third statement she makes is that about the throwing the weapon out of a car.
Yes.
You indicated in your filing that on March 1st, 82, about 5 months before these murders, the defendant was 16 years old, threw a handgun from a car while fleeing from an armed robbery at a convenience store. He was adjudicated delinquent for unlawfully carrying a firearm. You put that in your file. She quotes you on that. Does that ring a bell?
That's what it says. I understand. I corrected it. When-
Okay, that's what we put in first.
Correct.
Okay, and then she indicates that a fellow named Scott Kelly robbed a convenience store and confessed to throwing a gun out car window. In his confession to Detective William Hunwell, Scott Kelly stated, "I became nervous and wanted to get rid of the gun as soon as I could. I threw the gun out the window." And you submitted the reports of Honeywell, Drago, and Pasquarelli reports as part of Exhibit B to your affidavit. Even the most minimal degree of care and attention to what is being submitted to the court leads the reader to learn that it was Scott Kelly that threw the gun out of the car, not Chips. So that was a mistake.
Apparently.
And you further indicated that Chips was not adjudicated delinquent for unlawfully carrying a firearm. Oh, she said he was not adjudicated delinquent for unlawful carrying a firearm, which is what you said to the court. So that was wrong, correct?
I don't remember as I sit here today.
You will agree with me that the charge of possession of a firearm and carrying are significantly different offenses in the eyes of the law.
I don't know what the law was in the 1980s. and
Well,
that's
one
it.
of them was a 1-year minimum mandatory sentence, then, wasn't it? That FOC law went into effect in the early 90s.
I don't know.
Okay, but there's a mandatory on one and there's not a mandatory on the other, right?
I don't know.
She says you made significant omissions. The Commonwealth argues the victim's family opposes concurrent sentences and did not agree to the recommendation for concurrent sentences at Chip's original sentence. You recall stating that in your filings?
I said that I met with the victim's family, surviving family, around the time of that filing, and they told me then that they oppose concurrent sentences. I'm not sure that's what
You also wrote, there is no indication with whom the victim's family has discussed their current position. Atty Grant's affidavit significantly omits any reference to communications with the victim's family.
I think I represented in my filing to the court that I had met with the victim's family as required by Chapter 258B, Section 3, to inform them of the resentencing request and that they strenuously opposed resentencing.
She says you, contrary to what the ADA, meaning you lead the court to believe that Chip's sentencing, the victim's family concurred with the prosecution's recommendation for concurrent sentences.
Well, at sentencing, Bob Banks made a recommendation for concurrent sentences, and he informed court that he discussed that recommendation with the family and they concurred. At that point,
But you put in your filing now at this event,
correct?
I quote what you filed. Contrary to the defendant's present claim, the record does not reflect that the victim's family members agreed concurrent sentences were appropriate. D memo 3-4, 36. Rather, the prosecutor informed the judge that he had spoken with Mrs. King's daughter, and she has generally left it to the Commonwealth to make the recommendation, period, end of quote. That's what you put in file.
And as I
Okay.
explained earlier,
Just, yes, that's what you put in.
correct.
Okay. Bob Banks, in his filing back the original sentencing, had it a little different. I might add, Judge, that prior to making that recommendation for concurrent sentences to you, I have spoken with a number of police officers involved in the investigation, in particular with Mrs. Gear, who is the surviving daughter of Mrs. King and the surviving niece of Mr. Lucy. And she was generally left it to Commonwealth to make a recommendation. To make recommendation, we do feel the recommendation is appropriate. She knows what I am recommending and she concurs with it. That was the concurrent sentences. Correct?
Correct.
You didn't say that in your statement. You left out the sentence. She knows that I am recommending and she concurs with it. You took the position that the family never occurred breach of the concurrent sentences in this hearing.
I quoted the first part where it said that the family left it to him to decide. I don't see that as being that different from concurs with it, but
your filings, according to this document, the Commonwealth now argues the victim's family never agreed to concurrent sentences, and that Chips is trying to put words in their mouths for his own self-serving purpose, end quote. You remember making that statement in your filings?
yes.
That was not true. That was not true.
What happened was
No, was it true or not?
was
That the victim's family never agreed to concurrent sentences? Is that true?
the issue is 2 different points in time.
No, I wanna talk to you about what Banks said at the hearing and what you said at this hearing in 2016.
Approximately.
Okay. You said in your transcript, the Commonwealth now argues the victim's family never agreed to the concurrent sentences. That's what you said, right?
Correct.
Okay.
But
Okay. In your paraphrasing what Banks said, you left out the sentence that says she, the victim, knows that I am recommending what I am recommending, and she concurs with it. So back when Judge Banks and Prosecutor Banks wrote this sentencing, she agreed with the concurrent sentences. That's what you put it.
correct.
You didn't put that in your statement. You paraphrased it differently. You said, contrary to the defendant's present claim, the record does not reflect that the victim's family members agreed concurrent sentences are appropriate. You wrote that.
There's another piece of information that might clarify this.
Is that what you wrote?
That's what I
And Banks said she concurred.
correct.
So those are 2 different statements, I think.
But this piece of information that might clarify this.
What?
When Ms. Belger initially filed the motion for resentencing, one of the reasons she asked for resentencing was that she said the family concurs.
Mhm.
And she said that based on the representation
Banks
at
made.
sentencing that Banks made.
Yeah.
I met with the family, the surviving grandson and son-in-law in approximately 2016,
Mhm.
as I'm required to do under Chapter 250B, Section 3, and informed them that she had filed this motion for resentencing, and they very strenuously opposed concurrent sentences. That's their statutory right.
Okay.
I-
Well, did you say to them that back when the sentencing was happening, you told ABA Banks that you agreed with the concurrent sentence?
They didn't tell that to the daughter. So what happens is the adult woman, the woman victim's daughter was the one that Banks spoke to at sentencing and represented that she concurs.
Okay.
But by
yeah.
the time of the motion for resentencing, she had died. And so the family members left were her husband, widower, who's the one who discovered the victim's body, and her son. I mean, so the deceased woman's grandson and her son-in-law. Those are the ones that we met with in approximately 2016 as the
Okay.
250P
But-
requires.
Okay. But
So
that's not what you said here.
my point,
That's not what you said. You said victim's family never agreed to concurrent sentences. You said that. That was incorrect. They agreed with Banks. It's right here.
They
She
concurred
knows
with
what I'm
Banks.
recommending. She concurs with. Didn't she agree?
she concurred.
Okay. So when you said they never agreed, that was
Oh.
incorrect. Was it not?
Yes.
Okay. And Chips is trying to put words in their mouths for his own self-serving purpose. What words was he trying to put in their mouth?
That he was representing to the judge as of 2016 that the family as of 2016 concurred.
Why
with
wouldn't he? That
concurrent
was in the
sentences.
document from Banks. Why wouldn't he? He'd try to put words in their mouth. It's already been done.
Because there's a statute that requires victims to have input for a sentencing hearing.
I'm talking about you put in here to the judge and quoted, put words in their mouth for his self-serving purpose. All he did by way of a lawyer is to put in what Banks said. Isn't it correct?
I understood to be a representation to the court that in 2016, the family would not oppose resentencing.
He didn't even speak to the family in 2016.
I don't know.
Well, you met with him? You say, did the defendant come out of jail and visit you, or did you visit him? Did the lawyer come visit you? Of course he didn't. Did they? They didn't
Not
visit
to my
the
memory.
victims. And you left out the most important sentence of all in your presentation. She knows what I'm recommending, and she concurs with it. You left that out, and you paraphrased Banks. Didn't you?
I did that out.
No.
No.
How's it possible to read what Banks said, quote almost most of it, and leave out that one very important sentence when you were saying and making the case that the family didn't agree with concurrent sentences, and you left that out of your file to Connors? How did that happen?
I don't know.
I mean, these things are important. These things you file, end up in appeals court, and you read things about these words in their mouth. The parole board gets them. They say the guy's trying to be a con man, put words in people's mouths when they didn't exist. You filed a motion to strike. Commonwealth's response to the defendant's motion to strike, because Belder filed a motion to strike what you put in your filing, right?
I didn't move to strike anything
No.
of hers. I
No,
filed a
she-
response.
She moved to strike,
Correct.
and you filed a response to that motion.
Correct.
A two-page document, February 2nd, 2017.
Correct.
And in that document, you said the information exhibits A and B was obtained from trial prosecutor's file from the 1984 trial.
Correct.
The police report contained in exhibit B are photocopies more than 32 years old. Most of them are handwritten and they'd be difficult to read.
Says many are very difficult to read.
It was entirely inadvertent. The unsigned counsel included Commonwealth's December 2016 filing some documents not relevant to the case. Correct?
Correct.
So the reason you couldn't read the documents, so you just put them in? The Commonwealth concedes they are unrelated to the defendant. The Commonwealth filed them under seal. The papers show the OUI was dismissed, blah, blah, blah. And you asked the court to strike certain things in your file and edit it before you, correct?
Right. That's how it was phrased.
Have you ever asked a judge to edit your filing before?
I don't remember.
I've never heard in 42 years of being in courtrooms, any ADA or any defense lawyer saying to a judge, I'm going to give you this, by the way, to edit my filing. No judge would do that, would they? Well, let me ask you this. You were on the appeals court and I came up and said, oh, by the way, I made a mistake. I'm going to give this judge. Can you edit my filing? What would you say to me?
I actually have seen that in the appeals court when something is filed with typographical error, for example. There's usually a motion to file a substitute brief. I could have done that here. The problem is that it might be hard for the judge to keep track of what the differences are between the two documents. And
So
this was
it
a,
also indicates, you indicated in your filing, the Commonwealth's December 14th affidavit, by striking the word, quote, through a handgun from car, quote, and including in their place the words, quote, was traveling in a car from which a handgun was thrown, quote.
correct.
Remember? Well, her concern with that was, isn't that a little disingenuous also? Whoever reads this is now thinking, well, who threw the gun out? It could have been him.
Well, that's
When
what
you
the
knew,
police said.
no, when you knew that he didn't throw it out, somebody else did. You knew that.
I don't remember.
You knew the police report showed that.
I don't remember.
Well, then why would you put that in? I was traveling in a car where handguns thrown.
I don't remember as I sit here today. What what the police report precisely said. I know I was very careful when I corrected it to say, to make it accurate, what the police
Well, that
report
wasn't
said.
accurate, was it?
I believe it was. But I
Well,
don't remember.
He might have been traveling in a car when John was wrong. You're leaving it like somebody reading at the appeals court or a parole board is saying, well, evidently he must have been the one that threw it out. You didn't say, I'm taking it out because someone else I know threw the gun out, so it's got no relevance to him. Right?
I don't know.
Okay. Striking the words unlawful carrying and including in the place words unlawful possession of. Okay?
Right.
And you know there's a big difference in that.
I don't know what the law was in
Well, what's a
1980s.
minimum mandatory? One is, right? No question. Carrying a gun without a license is a minimum mandatory sentence, isn't it? The Commonwealth agrees that the sentencing transcript, the trial prosecutor stated it as follows, referring to the surviving daughter of the victim, Mrs. King, who was also the niece of the other victim, Ms. Lucy. She knows what I'm recommending and she concurs with it. So now you changed it to put that in, right?
Correct.
But you told me a few minutes ago that when you met with the victims, they did not agree to that concurrence.
In 2016 or thereabouts. Correct.
So why would you put in that? She knows that I'm recommending and she concurs with it.
The transcript says that. It's
Yeah,
quoting the transcript.
it's motion. You
Right.
signed it, February 2nd, 2017.
And I'm quoting in quotation marks and cite to transcript 11, page 4.
Yeah.
That's what it says.
But you told us, you wanted to explain something. You said I met with the victim in 2016.
Correct.
And they said to me, no way were they going to agree to a concurrent sentence.
Correct.
Right?
Correct.
But you would put it in your filings. They agreed.
I put it in my filing. She knows that the transcript says. She knows what I'm recommending and she concurs with it.
Okay, a few minutes ago, you said you met with them and they didn't agree at all. And that's why you put the other
Those-
stuff in. That's why you said he's trying to put words in their mouths.
Those two things are inconsistent.
Okay. Anyway, anything else you want to tell me about all this stuff? Okay, I'm just looking at the stuff. I don't know your career entirely. It's been a good one. There's no question about it. But this stuff was either very slipshod work in a bunch of these things, not reading the file, putting things in that shouldn't have been in. So how do I know you're going to be that throwaway around the appeals court? How do I know that?
I'm very concerned about these allegations. I take very seriously. I've listened very carefully to what the three defense attorneys had to say. And I am sorry that I have made mistakes.
Mistakes, I made more of them in my life than I want to admit. I don't hold that too much against you. But it seems to me there's a little pattern of not being attentive to these filings. And from a lot of lawyers, some that didn't come in, the talk about you was that you did things for the government. You misrepresented things for the government. Chinnan says, you said, don't look in the files, you might have to turn over. I heard that from other people too. That was sort of your marker that got put on you. And I hope you're a judge that you don't revert to that kind of stuff. Be one of the judges that we say 5 years from now, everything is government. You assure me you won't be?
I can. I hope.
Well, I don't want you to hope. Love hope. But I want you to say, of course I will.
I will try my absolute best.
Well, that's all we can ask for. Okay, anybody else have any questions?
Just quickly, how many years have you been a lawyer?
31.
How many cases have you dealt with appeal?
It's in the triple digits. I'm not sure.
Hundreds?
Yep.
And there are, what, 3 that we talked about today?
Approximately.
My last question is there anything that you want to say that, to clarify anything, or that you have on your mind, or we're not about, or weren't able to respond to, that you want to say now?
I'm exhausted. So not that I can think of now.
Thank you.
Really appreciate all of your time.
Thank you.
Well, let me just say something to you, and I do appreciate you taking all my stuff I threw at you. Some of it I wanted to see how you'd react to, but I'm very thankful that you agreed with me that nobody has been vicious to you here. other than being in the ass. But nobody was vicious to you. Nobody treated you unfairly here. And you didn't think anybody here was picking on you because you were a woman. I thank you for that, because since I've been on this council, I've never heard of anybody that attacked anybody for being a woman or put somebody down in here because they were a woman. And I've never seen anybody viciously attack anybody. We ask questions, some of them aren't fun. But that's our job. You said to me, if you were sitting here, you'd do the same. I thank you for that.
Just one point, just to clarify, I was listening to Carol, talk, so thank you. Do you agree that you were treated fairly today?
Yes.
Don't agree. We had two
We
people,
didn't ask you, excuse me, we didn't ask you, Counselor.
we had two
You
people
wanna say
that
something?
work here.
Counselor, you want to say something?
Yes,
Go ahead.
we had two people that part of statements are put in to question. They were here to be asked questions by us, and I don't think that's fair. Thank you.
Duly noted. Duly noted, hearing over.
What time's the other hearing going to start, please?
That's crazy. We're gonna put these letters in your file. Okay, we have a letter from Bruce Ferg. He called me saying your praises. I've known Bruce a long time. Very clear use assistant district attorney, clear use assistant district attorney, and I know her from Oakland, Oregon. Catherine Folger. I don't know who Catherine is. Mark Rosenthal. Beverly Canoli. And Mike Morrissey. I think did he say something? Did he say something? He didn't call, no, he called one of the council, spoke very highly. What do you need here for, putting you this in the file here?